In the early 1950s, the United States was a deeply divided nation by race. Jim Crow's laws, which institutionalized segregation, were entrenched in every aspect of American society, including public education. African American children were forced to attend separate schools, often inferior in resources, facilities, and quality of teaching. Yet the 14th Amendment to the U.S. Constitution guarantees equal protection under the law. This paradox created a constitutional crisis. In this environment, a case began to take shape in Topeka, Kansas that would change the very foundations of American legal doctrine, Brown versus Board of Education. This case would question the legal principle of separate but equal established in the Supreme Court case Plessy v. Ferguson in the year 1896, and forced the Supreme Court to confront the systemic inequality perpetuated by segregation in public education. Linda, the education I want for you is just down the road at summer school, but because of the color of your skin, you can't attend. You'll have to walk all the way to Monroe, the black school.
But Papa, Sumner is so close. Why can't I go there?
Because of segregation, Linda. We're going to change that. We're going to fight for what's right. Thank you, Marshall, for coming. Mr. Brown, we are committed to fighting this injustice. The NAACP is prepared to take this case to the Supreme Court. Your case is not just about Linda. It is part of a larger battle for equal educational opportunities for all children, regardless of race. Do you think we'll have a chance? With your courage, Mr. Brown, we have more than a chance. We have the law and justice on our side. This is a fight for equality, a fight that will resonate for generations to come. We will now hear the case of Brown versus Board of Education. Mr. Marshall, you may proceed. Thank you, Your Honor. We stand before you today to challenge the constitutionality of school segregation. The central issue is whether separate schools for black and white children can ever be equal, as required by the doctrine established in Plessy v. Ferguson. The doctrine of separate but equal has never been an accurate representation of equality. Separate schools, by their very nature, breed inequality. The resources available to black schools are substandard, both in terms of physical facilities and educational quality. But the greatest harm of segregation is psychological. It tells children that they are inferior, simply because of the color of their skin. Your Honor, in our study, we presented African American children with 2 dolls, one white and one black. When we asked which doll was nice, most children selected the white doll. When asked which doll was bad, they pointed to the black doll. This demonstrates the harmful effects on segregation on children's self-esteem, creating a deep psychological sense of inferiority. This testimony directly undermines the argument of the defendants. Segregation is not just a matter of separate facilities. It inflicts emotional and psychological harm that lasts a lifetime. The question before us is whether Plessy v. Ferguson can be reconciled with the equal protection guarantee of the 14th Amendment. Can separate facilities truly be equal? It is well established that states have the right to regulate public education. Shouldn't we be cautious about overturning a precedent that had stood for nearly 60 years? While we must consider precedent, we cannot ignore the profound social and psychological harm caused by segregation. Public education is the bedrock of democratic citizenship. Denying equal educational opportunities based on race undermines the very principles on which this nation was founded. But what if we rule that segregation is unconstitutional? What will this mean in other areas of law? Won't it lead to a widespread of social disruption? The disruption is not in ensuring equality. The disruption is in maintaining an unjust system. Equal access to education is not a privilege. It is a fundamental right. In a unanimous opinion of the court, we find that separate but equal has no place in public education. Segregated schools are inherently unequal. Therefore, segregation in public education violates the Equal Protection Clause of the 14th Amendment. Public education forms the foundation of good citizenship and societal harmony. Denying children equal access to education based on race deprives them of opportunities that shape their futures. We are compelled to declare that the doctrine of separate but equal is constitutionally untenable. The time for change has arrived. While this decision marks a significant step forward, its implementation will require courage from both lawmakers and the citizens of this nation. The responsibility to uphold justice now rests with all of us. This decision is still a victory, but it is only the beginning. Equal education must be the right of every child. We will continue to fight for justice, and this decision gives us the foundation to carry it forward. Brown versus Board of Education was a monumental victory for civil rights, but it did not end the struggle for equality in America. Resistance to desegregation was fierce, especially in the South, yet legal victory laid the foundation for further civil rights advancements. Thurgood Marshall would continue to fight for justice, ultimately becoming the first African American Supreme Court Justice. This case reminds us that the struggle for equality is an ongoing process. Every victory is a step forwards, but the fight is far from over. To those of you who watch this, I say this: justice is not given, it is fought for. The law is not an abstract concept. It is a tool to ensure that the promise of equality under the Constitution is fulfilled for every citizen.